we were coming for a ruling, there is an issue that has emerged which we wish to address the court before you deliver that ruling about the question of the fate of the accused persons.
Just a moment. Just a moment. We finish with introduction first before we go to issues.
Oh, sorry. I beg your pardon. You know, yesterday...
Mr. Ndegwa?
Yes, Your Honor.
If a matter is coming for a ruling...
Yeah, but it's a very sensitive issue, Your Honor. I would wish you to hear us about what happened when you issued your orders for the accused person to be held at Gaucho. Serious one, Your Honor. I wish you could hear us, and then you'll give your ruling. Any medical facility up to now. He has not taken any medication. He was held in police cells at Gaucho. You know, and again, he was not allowed to access any foods. All the accused persons. Number two, Your Honor, and the most grievous one. Is that when they were at police station at around 1 a.m., our clients tells us that a group of well-built up men, totaling to about 30 in number, were released to the police cells by the police with instructions to assault, maim, and perhaps even eliminate the accused persons.
I'm writing, please.
You know, our clients discloses to us, and most importantly, the second accused person, when he left your court yesterday, he was a man fit enough, but today he's all dented, having been assaulted. He has bruises, all over his body. And all that happened in a police station, Gaucho police station, in a police cell. Your Honor, how did those people access
Just a moment.
the cell?
Mr. Mashikani, I think the volume of that microphone is too high. Adjust it downwards. Yes.
Who allowed entry and access? If we cannot be safe in a police cell or in a police station, where else will Kenyans go? Who else shall protect these Kenyans? You know, as I before I invite my learned friends, just to make an observation on it, permit me to inform you, Your Honor, that Article 25 has outlawed any form of torture. I have two applications to make, Your Honor.
Just a moment. Mr. Ndegwa, why do you insist that I have to hear you before delivering the ruling?
You know, because you have heard the gist of it.
I just want to understand you. Why do you insist
the
that
application I'll be making will require the attendance of the OCS, Kileleshwa Police Station, to come and tell us what happened.
Okay.
Number two, I'll be making an application for
just a moment, please. I think now we need more order. Is it an application you feel I will not be able to hear after delivering my ruling?
No, you can hear it. I'm well guided.
Is it not proper that I first deliver my ruling, then I hear your application?
I'm well guided by your wisdom, Your Honor.
Okay.
I oblige.
Okay. So we'll pause there. Once I'm done with my ruling, then you can pick up from where you have stopped.
I'm well guided, Your Honor.
Thank you.
I'm well guided.
The ruling is a short. Jointly face a charge of conspiracy to commit subversive activity contrary to Section 77, subsection 1 of the Penal Code. Each of the 7 accused persons denied the charge. In the notice of filed on the same date, expressed as brought under the provisions of Articles numbers 24, 25, and 49, sub-article 1, F, G, and H of the Constitution of Kenya, and sections 26A and 123A of the Criminal Procedure Code, and all enabling provisions of the law. The prosecution sought the following orders, namely, I quote, that the application be heard on priority basis upon each of the respondents taking plea. Number 2, that the Honorable Court be pleased to find that the prosecution applicant has established compelling reasons to deny each of the respondents bail. Number 3, that pursuant to prayer 2 above, this Honorable Court be pleased to deny each of the respondents bail and to order their detention pending the completion of investigations. the basis of the instant charges. End of quote. The application is based on 4 grounds on the of instant charges. Number 3, that there is real likelihood that each of the respondents will interfere with witnesses to be called against them in support of the instant charges. And finally, 4, that there is real likelihood that the respondents will continue committing similar offenses were they to be released on bail. End of quotes. The application is further supported by a 14 paragraphs affidavit sworn by number 75579 Corporal Geoffrey Mwangi, filed on 20th of July 2023. The application was heard by way of oral submissions by both the prosecution counsel and the defense counsel for all the accused persons. And with respect, I will not reproduce the submissions made by the said counsel in this ruling, owing to constraint of time. I have perused the application, the supporting affidavit, and considered the submissions made by counsel and the authorities relied upon in the course of submissions. The main point for determination is whether the prosecution has established compelling reason why any of the accused persons herein should not be released on bail or bond pending trial in line with the provisions of Article 49, Sub-Article 1H of the Constitution of Kenya. What constitutes compelling reason is well captured in the case of Republic versus DKN 2021 EKLR, where the High Court said as follows, I quote, "The Court of Appeal in Michael Juma Oyamo and another versus Republic 2019 EKLR adopted the definition of the phrase, quotes, compelling reasons in the case of Republic versus Jackton, Malande and 3 others, criminal case number 55 of 2009, where the learned judge held as follows that, quote, the phrase compelling reasons would denote reasons that are forceful and convincing as to make the court feel very strongly that the accused should not be released on bond. Bail should not therefore be denied on flimsy reasons, but on real and cogent grounds that meet the high standards set by the Constitution," unquote. The court went further to lay down some of the compelling reasons to include the likelihood that the accused will fail to attend court, commit or abet the commission of a serious offense, endanger the safety of victims, individuals, or the public, interfere with witnesses or evidence, endanger national security or public safety, and where it is necessary for the protection of the accused. Section 123A of the Criminal Procedure Code, which was introduced by Statute Law Miscellaneous Amendment Act of 2014, provides as follows, quote, subsection 1, subject to Article 49 1H of the Constitution and notwithstanding Section 123, in making a decision on bail and bond, the court shall have regard to all the relevant circumstances, and in particular, A, the nature and seriousness of the offense, B, the character and antecedents, associations, and community ties of the accused persons, C, the defendant's record in respect to fulfillment of obligations under previous grants of bail, and D, the strength of the evidence of having committed the offense. Subsection 2, a person who is arrested or charged with any offense shall be granted bail unless the court is satisfied that the person A has previously been granted bail and has failed to surrender to custody, and that if released on bail, whether or not subject to conditions, is likely that he would fail to surrender to custody, and B, should be kept in custody for his own protection. The bail bond policy guidelines under Section 4.9 further lists factors to be considered in determining what compelling reasons are and include A, the nature of the charge or offense and the seriousness of the punishment to be meted out if the accused person is found guilty. B, the strength of the prosecution's case. C, character and antecedents of the accused person. D, the failure of the accused person to observe bail bond terms on previous occasions is a good ground for denying bail or bond. E, likelihood of interfering with witnesses. F, the need to protect the victim or victims of crime from the accused person. G, relationship between the accused person and potential witnesses. H, child offenders. I, accused person is a flight risk. J, whether accused is gainfully employed. K, public order, peace or security. And L, protection of the accused person. End of quotes. The principal consideration in every application with regard to whether or not an accused person should be released on bail or bond pending trial is whether an accused person, if so released, is likely to turn up for trial. That is premised on the presumption of innocence as provided under Article 50, Sub-Article 2A of the Constitution of Kenya. The nature of charge, however, is a relevant consideration, presumption of innocence notwithstanding, but bearing in mind still that every charge is subject to proof to the required standard. The charge against the accused persons is punishable by a term of imprisonment for 7 years. Section 77, subsection 1 of the Penal Code, under which the charge is preferred, provides as follows, I quote, any person who does or attempts to do or makes any preparation to do or conspires with any person to do any act with a subversive intention or utters any words with a subversive intention is guilty of an offense and is liable to imprisonment for a term not exceeding 7 years. End of quotes. In their submissions, the Prosecution Counsel relied on the provisions of sections 26A and 123A of the Criminal Procedure Code and paragraph 4.9A, C, and E of the Bail Bond Policy Guidelines. One of the reasons advanced by the prosecution is that the accused persons are likely to interfere with witnesses. It is not specified which of the 7 accused persons is likely to interfere with which witness and the likely manner of such interference. The authority of Jeffa versus Republic, 1973, East Africa Law Reports at page 39 is relevant to the matter at hand. In that case, it was held at page number 41 as follows, I quote, time and again, this court has said that the true test of a bail application is whether the granting of the application would be detrimental to the interest of justice. It is for the prosecution to satisfy the court that this would be so if bail is granted. Dealing with the question of tampering with witnesses, Wilson, acting CJ, as he then was, said in Bagwaji, Kakbai versus Republic, Volume 1, Times Law Reports at page 143, quote, the test laid in English cases were that there should be a definite allegation of tampering or attempted tampering with witnesses supported by proved or admitted facts showing reasonable cause for the belief that such interference with the course of justice was likely to occur if the accused was released. In the present case, there was no more than mere assertions by the prosecutor that the applicant would interfere with the prosecution witnesses if released on bail, end of quotes. The defense counsel submitted that the affidavit in support of the application is not dated. The prosecution counsel in response submitted that the averments in the affidavit are the same as the grounds on the body of the application. there is no dispute that the supporting affidavit on record bears no date. Section 5 of the Oaths and Statutory Declarations Act, Chapter 15 of the Laws of Kenya provides as follows, I quote, "Every commissioner for oaths before whom any oath or affidavit is taken or made under this act shall state truly in the jurat or attestation at what place and on what date the oath or affidavit is taken or made," end of quotes. The jurat, excuse me, the jurat on the affidavit in support of the application does not satisfy the requirements of the said provision alongside Rule 10 of the Oaths and Statutory Declarations Rules and the schedule thereto. The Prosecution Counsel urged the court to invoke the provisions of Article 159 of the Constitution and overlook the defect of non-indication of the date on the affidavit. That invitation is merited, as the court ought to focus on administering substantial justice with minimal focus on peripheral defects. As Gikonyo J. said in the case of Barnaby Properties Limited versus Sandra Stocks Limited 2015 EKLR, when dealing with objection on defect in the jurat, I quote, "We are most lucky jurisdiction now that Article 159, Sub-Article 2D of the Constitution expressly depreciates such technicalities in favor of substantive justice. I dismiss the objection based on jurat and hold that the affidavit is proper for all purposes of and intents," end of quote. Nevertheless, a holistic look at the said affidavit does not disclose compelling reason to warrant denial of bail or bond to the accused persons herein. In the sum, for the foregoing reasons, I find that the notice of motion dated 20th of July 2023 is not merited for the reason that the prosecution has not established compelling reason to warrant denial of bail or bond to any of the accused persons herein. What then remains for determination is the bail and bond terms, taking into consideration the nature of charge, presumption of innocence notwithstanding. I consider the following terms appropriate and reasonable. Each of the 7 accused persons is granted bond of Kenya shillings 200,000 with one surety of the same amount, with alternative cash bail of Kenya shillings 100,000 with one contact person. Orders accordingly, and that is the end of the ruling.
We are most obliged, Your Honor.
Yes. So, Mr. Ndegwa, you can pick up from where you
Yes,
stopped.
sir, I have one torture or cruel and inhuman treatment of any person, not just the arrested persons, any persons.
Your Honor, sorry to interject with respect to my learned colleague, and I take very seriously the allegations that he's making. It's very unfortunate that those allegations have to come from the bar without any document in support of those allegations, and we have to sit and listen. I would plead with him, still again upholding the seriousness of those allegations, that he maybe looks for a way or his plans getting out. Meanwhile, bring something that this court can look at, because we are officers of this court and we know the rules. The rules are that he cannot be giving us matters of fact from the bar. However very serious we take them. So we invite him that he may indulge us, gives us some document that we are able to respond to, because we'll be required as the state to respond to these allegations. Thank you.
objection by learned counsel. JB, with you. Your Honor, what learned counsel is telling you is that if there is contempt on the face of the court itself has to file an application to deal with that contempt.
Look at the second accused person. He was before you yesterday. This is what we are told. We need to file an affidavit to now show that he's injured. Look at him. I wish JV can turn and look at him. It is that serious. We don't need an affidavit. We have a live person. We have evidence before this court. The practice here is that the investigating officer is in court. He ought to take a witness stand and indicate to us whether the grievous harm that has been occasioned to a person under their protection is true or not. We cannot belittle that. Over and above that, Your Honor, the infringements that have happened go against Article 51, 1 and 2, which are very clear that even an arrested person and anyone in custody or even a convict still has rights, the basic human rights. This is a father to someone who has been beaten like this. It is not business as usual. Article 29 is also very clear. You cannot subject a person to degrading and inhuman behavior. It is not business as usual. And we will not accept JV's submission that if we take it in terms of what he submitted yesterday, you violate someone's right, then you come and say this court can only watch and take us to the High Court. No, this court cannot be blind to people who are subject to this court. We will say this, we will apply to this court, and the applications being made by my learned colleague, Mr. Ndegwa, are applications that ought to be had before this court.
You know, I am very perplexed by the conduct of the infringed. The day his rights will be infringed, we shall still come before
I will
you.
object to that line of argument. I took it yesterday and I will not take it today. When my time comes to be in prison,
The day-
in the cells, Counsel, I'm on my feet kindly. I will be dealt with at the time. Fine, thank you. My apologies.
I have seen the second account, even as the issues surrounding where, how, and under what circumstances the injuries were sustained is being addressed. The accused persons have just been granted bail or bond. There are complaints about how they were treated in custody. It is necessary that they be given a chance to have their bail processed for those who are able to pay the bail. The defense counsel are raising serious issues based on evidence flowing from the bar for an orderly hearing of the applications being made by the defense. It is necessary that a formal application be filed and served so that the prosecution can file their responses if they deem fit to file the same. So the application be filed soon as possible, and the matter be mentioned on Tuesday, 25th of July this year, to address the issues upon filing of the applications.
We are most obliged by that.
You may or you may not agree with my direction.
We agree with them entirely. We
Okay.
agree with them because it's harmonic wisdom. Only one problem that we foresee ourselves facing, that the issues we are raising occurred in a police station. For us to be able to get a P3 form, we must record a complaint before a police officer. Most likely, we have to record that complaint before that particular police station. Your Honor, the question is, will these people be ready to bite the hands that feeds them? So we foresee a problem here. So if you can just facilitate the process, a further order which is facilitative in nature, that this complaint be recorded with iPod, so that Your Honor will have an OB somewhere, and a P3 form will subsequently ensue. Because even if we go to the officers, to the hospital, without that P3 form, we still have problems in him being treated and that issue being addressed. I don't know whether my learned friends agrees with my position, Mr. Gaucho.
Thank you, Mr. Ndegwa. I'm not sure whether IPOA needs an order to receive a complaint. Do they?
Our issue is, where do we record this complaint? This court is pursuing the protection and upholding of the Bill of Rights. You can compel the OCS Kileresho police station to take our complaint, so that then if he doesn't, we'll have them to come before you once again and tell you that the OCS has declined to take our complaint.
Your Honor, just to assist court, we undertake, the RCIO is here, Mr. Pro. Just a minute, Mr. Ndegwa. Just calm down, Mr. Ndegwa, kindly. Mr. Pro, just assure court, just stand up that we will get the complaint recorded at the Kileresho police station today. I will talk to counsel today, direct them to contact.
This person,
Please have a seat. You see now we are behaving. Are we making a gang inside the courtroom? So that we start shouting at each other. I think, Mr. Ndegwa,
yes, Your Honor.
you have the discretion out of experiences of many years.
Yes, Your Honor.
If you have somebody who is alleging to be sick, is alleging to have been assaulted,
Yes, Your Honor.
if I were in your position, the best thing I would do is to ensure the person gets out as fast as possible
We are processing.
and gets medical attention as fast as possible.
Yes, Your Honor.
Because there could be external, but you cannot see the internal injuries, if any.
Yes, Your Honor.
You go to hospital, get your treatment notes.
And
Then once the person is okay, then you can then follow up the other issues.
Your Honor, we are most obliged.
First things first. So please, if you follow what I'm telling, stop there. We are going to have a break. I'll be back in a short while on Tuesday.
Wamekaa wengi lakini pia state tunasema
with demonstrations, Your Honor, that the accused
Lydia had disappeared to another country.
Your Honor, specifically, I wish to submit that in favor of the accused person, unless he, I think he was going the other day. What I am saying, Your Honor, is that
of criminal question. Okay. Your Honor.
Then the court must then look at Article 20 and 21, whereby after recognizing the fundamental rights and that they exist, then the courts must start by acting in a way that wants to grant those rights rather than deny them. And this does not only include the court, it includes the police officers and other state officers. Yet, they come to this court and give you such an affidavit.
So we mention this case later at 2:15 p.m. for directions on the ruling because of the reasons that I've given.